There we go. All right. So good afternoon, everybody. And thank you so much for joining us at Secular AZ today. Again, if you are joining, feel free to put your name in the chat. Make sure you click the blue button on the bottom that switches from host panelist to everyone in the chat. Um, as you all know, white Christian nationalism is the greatest threat to our democracy, and Secular AZ is your voice for the separation of religion and government. We are a nonprofit organization, and we act as your voice to elected officials all across the state and at every level. So be sure to check out all of our social media channels and like, subscribe, and share. And again, this may seem little, but it actually helps us to kind of rise to the top on searches for our posts to get to more people. So please, anytime you see something we post or a new video, be sure to like it, subscribe, and share, etc. All right. Next week, feel free to join us on Monday evening for a special school board candidate forum with candidates from the Catalina Foothills Unified School District. This is one where all candidates have RSVP'd, so I'm really looking forward to that. Next Friday, we will be hosting another candidate forum for the Maricopa County School Superintendent election, so you won't want to miss that. Now, originally today, we were supposed to speak with Professor Kevin Parkinson, who was targeted last year or earlier this year by Turning Point USA, but Kevin's legal counsel has advised him to postpone until he's kind of cleared all of his legal hurdles. So what better way to pivot on this Rage Friday than to have our very own legal director, Dianne Post? She is going to share an update about the many complaints she's received this year. If you don't know her, Dianne Post received her JD from the University of Wisconsin in 1979. She was a family lawyer in Arizona for 18 years, representing mostly battered women and abused children, before beginning a career in international law, primarily doing gender-based violence work. On the international level, she has worked for the US OSCE and the UN in Russia, Mongolia, Algeria, Cambodia, Kenya, and other places. She coordinated the group in Russia that drafted the first trafficking law and worked with the former head of the Constitutional Court in Kenya to create a manual to train prosecutors to prosecute cases of sexual violence against children. And there's so much more to her resume, honestly, that she could probably talk about that for an hour, but instead, she's going to provide us with updates today. So, Dianne, I'm just going to go ahead and hand it off to you, and I will monitor the chat.
Okay, well, I'm sorry to tell you, Jeannie, that I didn't actually prepare an update on our legal cases. And the reason is there is so much going on that that's just going to have to wait till our annual meeting when I do that. I just thought there's so much else important going on that I should talk about. So Jeannie did, and this I blame on her, she did ask me to cover a whole bunch of things. The IRS complaints, open meeting law, what's going on with that teacher in Higley, the propositions on the ballot, and the down ballot issues. I do talk fast, but I cannot possibly cover all those things in an hour. So here's what we're going to do. I'm going to start out with the IRS complaints, which is going to be fairly short. Then I'm going to go to what's probably the most interesting to people is the Higley teacher, what's going on there. During that time that I'm doing these presentations, I want you to vote. What next do you want me to talk about? The open meeting law, the propositions, or down ballot? And then Jeannie and Lindsay will be figuring out what you voted for, and that's what we'll do. All right. So we also are going to put into the chat an article, more detailed article that I wrote about the proposition. So that will be written and in the chat that you can download if you're interested. And also I'm on the State Now pack, and we have got over 100 endorsements of people all up and down the ballot, including school boards and justices of the peace, etc., that we will also put in the chat so that if we don't get to that, you can still download that and have that information. All right. So we're going to start out with IRS complaints. There's not a heck of a lot to say because the forms and the procedures and the explanations, they're all on our website. It's very simple. But you do need proof. If you see something that is a violation of a 501c3 or a religious organization, a church and whatever, campaigning, which they are not supposed to do, then you need to have the proof, whether it's a flyer or a video or an advertisement on social media, whatever it is, to send to the IRS. And we've put in the website, the place to send it, how to send it, etc. The problem is they never investigate. They only investigate us and not the Christian nationalists. Every time I file a complaint, and oh my God, I've probably filed, I don't know, 20 or 30 by this time. I always put in the extra paper that says, if you collect any money from this taxpayer, we get 10% of it. Well, why not? Every time I get a letter back that said, oh, well, we didn't go forward with this complaint. So I know they're not doing it, but we want to keep filing those things anyway. Why? Because someday somebody is going to file a public records request or a FOIA, because it's a federal agency, the Freedom of Information Act, and they'll file a request and they'll say how many complaints were filed against religious organizations, how many were filed against other 501c3s. And what they will see then, and how many were followed up with religious organizations? None. And how many were followed up on other 501c3s? All of them. So they will see the disparity between the investigations, that they investigate us for violations, but they don't investigate the religious side. It's very much biased. It's very much one-sided. But keep making the complaints, because that way we can have the proof at some point in time that we get, what we need for national administration and IRS person to actually do something about this. So any questions, Jeannie, in the chat about IRS?
Not in the chat, but I want to just say that when I spoke with our tax preparer, the advice that she gave us was, if you have somebody like who has time and has a complaint and can sit on the phone for sometimes hours and hours and hours and perhaps even get disconnected, because that's happened to me before, you're far more likely. So for those of you, perhaps when you're done phone banking for your favorite candidates or your favorite propositions this year, you could spend that time, and I'm serious here, like you can spend that time actually making calls to the IRS every day, and who knows, maybe we would see more of these complaints actually be taken seriously. So that's just my 2 cents.
I saw a note that just went in the chat that says a neighborhood has a no on 139. Oh, neighborhood church. Now, that's the thing. They can campaign on issues just like we can, not for people. So they're a church, they're against abortion, they've got no on 139. They can do that. So can we. What they cannot do is campaign for a person. So that's not a complaint. Don't bother wasting your time on that, because it's not a violation. Anything else, Jeannie? Okay. So be sure to get in the chat your vote on what you want me to follow next. Okay. Next, I'm going to do this Higley teacher. This is so stupid, I can hardly believe it. Okay. It's a college level literature class at Williamsfield High School. It's offered for dual enrollment with Chandler Gilbert Community College. And the book is Homegoing, from a Ghanaian American author. Can't pronounce the name. It's a prize-winning book. I haven't read it, but I read about it. It's a historical novel that follows the descendants of one woman in Ghana, and then how her descendants' lives evolved, those that stayed in Africa, those that were kidnapped and brought to the United States or Brazil or other countries. And so that's the timeline, or the progress of the book. And I'm going to go read it now that I heard about it. I hadn't heard about it before. So the father had filed a police report. A father of one of the students in the class. The teacher is Brittany O'Neill, and it's a multicultural literature class. Allegedly, the police tried to interview her on September 19th. I don't know if they did or not. I hope she didn't talk to them. The parent is Charles Seals Villafranca, who tried to file previously a complaint with the Gilbert police, and they refused. Well, they should have kept refusing, and I'll tell you why in a minute. This father claims that the book has sexually explicit content, and he did not give permission for his child to read it. The district and the community college both said they approved the book and support the teacher. All right. So the statute that this father is referring to is 2495, but it's not the bill, because the bill got changed during the process, and the actual statute that's in place right now is a little different than the bill. Was passed in 2022, and our governor then was Ducey, and he signed it. So the statute is, if anybody wants to look it up, it's Arizona Revised Statutes 15-120.03. It's called Sexually Explicit Materials Prohibition Exemptions Definition. All right. So what you cannot do is refer students to or use any sexually explicit material. This materials are exempted from this provision if they have educational value for minors or possess serious literary, artistic, political, or scientific value. Well, that's the Supreme Court definition of obscenity. It's been the definition of obscenity from some years ago. So that's what that is. So that got added into the original statute. What it requires then from there is that the public school requires written parental consent before the public school can refer a student to use this material. And it's on per material basis. So this is what he's complaining about, is that he did not give written consent. Whether he was asked or not, that is completely unclear. He might have been asked, or it might have been a notice sent out and he didn't follow up on it. You know, it could have been his fault and nobody else's, but we don't know at this point. In the statute, they define sexually explicit materials. It is absolutely ridiculous in that it covers touching someone with their clothes on. You can have your clothes on and someone touches you in your buttocks, your genitals, your pubic area, your breast if you're a female, etc. I mean, it would be almost impossible not to violate this in some way or another in the way that they have defined it. So you could make a case about just about anything being a violation of this. Of course, it also covers, intercourse and fellatio and that sort of stuff, but some of it is very, very broad. But here's
Quick question.
Yes.
Quick question.
Yes.
Does this, somebody's asking, does this, they're asking what about sex ed classes, but I think that means, could this bill have the potential to ban sex ed classes?
I suppose it could, but you have to get permission from the parents for a sex ed class too. Right? So you would already have written permission for a sex ed class. But yet, yes, it would under the broad definition they have here, but all the parent has to do is give written permission for it and then it's okay. So that's how you would cover that, I'm assuming. All right. But here's where the kicker is in this one. There is no penalty in this statute. There's no penalty. And I looked and looked and looked and looked. There is no penalty. There's no criminal charge. There's no complaint against the teacher. There's no fine to the school, nothing. So the police have absolutely no jurisdiction in this case because there is no criminal penalty and there's no civil penalty either. Now, the only right the parent has, which is in 15113, is to have their student not have to read that material and get an alternative assignment. That is their only remedy for an alleged violation of this. Now, the fact that there is no penalty in this particular statute, it's not that they forgot or that they didn't know how to do it, because there are two other statutes that exist in Arizona law prohibiting teachers from doing certain things. Both of them have penalties. This one does not. In 5-717.02, that's the one, I think it's 15. I think I wrote it wrong. That's the one, I'm sure it's 15-717.02. That's the one that says teachers may not say that or put any form of blame on anybody because of race, ethnicity, or sex. And the penalty for that is that the teacher is reported to the teacher's board and could lose their certification, and the school is fined. So there is a penalty on that one. The other course is 15-112, and that is you can't teach about overthrowing the government, or all that also has a provision about promoting resentment toward a race or class of people. You can't teach that either. That has a penalty, which is the state can reduce the school funding in that particular school by 10%. So those two have penalties to go with them. This other one, under which this father is complaining, has no penalty. There is nothing for the police to do. They should never have taken this case. Now, I looked up to see if there was any criminal statutes that would cover this, and the only possible one is public display of explicit sexual materials, but public display is defined as a billboard, a theater, a newsstand, a vending machine, a window, blah, blah. Absolutely not going to be covered in school. So the police had better say, forget it, there is no crime here. Whether they do or they don't, I hope that she gets a good lawyer and sues the heck out of them. Well, because they're Gilbert police, but also because they never should have even entertained taking this case when there is absolutely no criminal connection. That's the end of my talk on that. Jeannie, is there any questions on this particular issue?
Well, this is a rhetorical question, but how on earth do you teach history?
You're right. That's a rhetorical question. All right.
Wait, okay, and then is there one more thing you're gonna talk about? Because the results are into the poll, so just so you can prepare, it's gonna be open meeting law.
Okay, open meeting law is the top vote getter. All right. Well, fortunately, that's next on my list. All right, so open meeting law. The statute on open meetings law, and this is ARS 38-431.1. It says, all meetings of any public body shall be public meetings, and all persons so desiring shall be permitted to attend and listen to the deliberations and proceedings. Listen. It does not say speak. It says listen. All legal action of public bodies shall occur during the public meeting. So that's your basic rule about what has to happen. Now, in part F of that, it says all or any part of a public meeting can be recorded, tape recorder, camera, or any other means. I recall recently, Jeannie, wasn't there someplace you went where they tried to stop a person from recording the meeting?
Oh gosh, there's so
read
many
about it.
meetings.
Yeah,
Well,
meetings.
yeah, go ahead.
It might have been somebody else, but I did read about where somebody at a public meeting, and it was not somebody on our side, somebody on the other side was trying to record the meeting, and they were told to stop, which is violation of this law. You can record the meeting so long as you're not disrupting it. And Section H of this law says, and this is important to remember, a public body may make an open call to the public during a public meeting, subject to reasonable time, place, and manner restrictions to allow individuals to address the public body on any issue within the jurisdiction of the public body. So there are three caveats there. Number one is a public body may have a call to the public. They do not have to. The easiest thing to do in these contentious school board meetings would be to stop the open call to public comment. Just stop it. Don't have it.
I agree. I never thought that I would take on that position, but at this point, when you've got 45 minutes, an hour, 2 hours of public comments of people saying the exact same thing, and most of it being just riddled with all kinds of homophobic and racist language, at that point, at the very least, move them to the end of the meeting, but even better, do away with them. Let people just do emails. Who cares?
Right. They can send emails, they can send letters, they can send texts, and they can voice their opinions. And certainly when election time comes, they voice their opinion, and they elect or don't elect certain people. They do not have to be allowed to speak at a meeting. And given what's happening, I mean, that would be my recommendation if I was the attorney for any of these things. The second thing is, in this sentence, subject to reasonable time, place, and manner restrictions. This is like a First Amendment, which is also subject to reasonable time, place, and manner restrictions. That means that they can make rules. The board can make rules about when people can speak, how long they can speak, what they can, not exactly what they can speak about, but the way that they are going to do their speaking. And I'll cover more in a little bit about what that specifically means. The third caveat.
Can I ask a real quick question, Diane?
Yes.
Because, actually, no, go ahead with the open meeting. I'll save it till later because it doesn't go with open meeting. So go ahead.
Okay. Sorry. Okay. So the third caveat in the statute is within the jurisdiction of the public body. So the comments have to be limited to something that public body can actually do. So if you're at a school board meeting, you shouldn't be talking about city council policy or legislative policy or United States federal policy. They can't do anything about that. So it has to be within the jurisdiction of the public body. And some of these things that I've watched that, Jeanne, you've turned us on to, they're talking about things that are going on the federal level, on the international level, on the city council level, whatever, that have nothing to do with the school board. And they don't have to let them do that because it's not within the jurisdiction of the public body. It should be focused on what that public body has jurisdiction over, which is education, education policy, that sort of thing, budgets, that sort of thing. Okay. Now, this was a change to the law a while ago, some years ago. In the past, board members could not respond to anything a person said. They changed that to say at the conclusion of an open call, individual members of the public body, so the members of the school board, may respond to a criticism made against them. So in the past, they couldn't respond at all. And they felt that was unfair when they were being targeted by members of the public, that they couldn't defend themselves. So they changed the law to allow them to speak back. They can't make any decisions. They cannot discuss any matter that the person brought up in the the public open meeting discussion. They can't talk about it and they can't vote on anything. But if you are attacked, you can respond if you so desire. You don't have to, but you can. All right. Now, I've already mentioned they do not have to have an open call at all. Now, the other issue about open meetings law, it's easier to find a violation. Well, it's not easy to find a violation at all, but you can see what's going on in a meeting. What the problem is, what's going on outside the meeting. That's the violation of open meetings law that is the most dangerous and probably going on that's very difficult to prove. So we have a statute about that nationally, and it says that it is not a violation of this article, the open meetings law, if a member of a public body expresses an opinion or discusses an issue, bloody. So a school board member can go out there on their own social media, write an op-ed for the newspaper, put a sign on their yard, vote down or up this bond issue. They can have an opinion on things and speak about it themselves to the public, to their constituency, whomever that is. What they cannot do. So that particular person, Jeanne, that we like to talk about all the time, she's on her podcast, right? She's taping things, she's making comments, she can do that. She can do that. Makes her look pretty silly, but she can do it. What they cannot do, and here's the two restrictions. The opinion or discussion is not principally directed at or directly given to another member of the public body. So when you're out there speaking your opinion about this teacher, you should not be principally directing that at another board member, because then you're trying to influence another board member outside of the meeting. But define principally, I mean, that's going to be difficult to know that it's principally directed at. And what if they just happen to listen to your blog post or read your blog post or listen to your, ranting on YouTube?
That makes me think of something that we started learning about at the kind of middle of my tenure on the board. I think it was called, is it called serial violations? Because of social media, because you don't know if somebody could see that you should not be posting, but there's no real consequences if you are, because there could be a serial open meet. I think that's what it was called. Like where, somebody sees it or somebody sends a screenshot or so, all that stuff. Yeah.
And then it keeps going. Right. And so then did the person who said it principally directed at another member? Or did they direct it at the public and the other member just happened to pick it up? Yeah, you see how difficult this gets. All right, so that's the first caveat. The second caveat is there is no concerted plan to engage in collective deliberation to take legal action. Prove that if you can. So in order for me to win a violation of an open meetings statute by something the group did outside of the public meeting, I would have to prove that those 2 or 3 or 4 or however many members of that board had a concerted plan. They had collective deliberations aimed toward taking some kind of legal action on the board. You see how hard that's going to be for a lawyer to try to prove that. They'll all deny they had a concerted plan. They'll deny they had any collective deliberations. If they just all happened to be at breakfast together at, Eggs R Us, it just happened. It wasn't a collective deliberation. So it's very, very difficult to prove these cases. That's why you see so many violations, or what you think are violations, you can't prove it. So there you go. Now, and this is not a new phenomenon, because of the importance of this and the issues that have been going on in the school board for quite some time, there's been 2 major attorney generals' opinions about this. The first one, well, I don't know about the first one, but one was from Janet Napolitano when she was the attorney general back in 1999. And it said, an open call to the public can be done. It does not violate open meetings law, but it's not required either. Members of the public body at that time cannot respond to comments at all, but that was changed later by statute to allow them to do so. The board can impose reasonable time, place, and manner restrictions. That's what the statute said. But any content-based restriction, if you're going to limit what the content is about what they talk about, it must be narrowly tailored to effectuate a compelling state interest. It can't be something about they're invading us at the border. That may or may not be a compelling state interest, but it doesn't have anything to do with the jurisdiction of the school board. So you can't interfere with the content unless you can show that it's outside of this jurisdiction, or it doesn't have any compelling state interest because it's not related to anything they can do anything about. And disruptive attendees can be removed. If they become disruptive, you don't have to leave them go on. You can stop them. Now, these are the kind of time, place, and manner restrictions that the courts have found okay. Now, these things are okay. You can limit the time, 2, 3, 5 minutes per person, whatever, it can be as little as 2 minutes. You can ban repetition. Now, Jeannie, you said earlier that hours this goes on and they all get up and say the same thing.
Yeah.
They can ban repetition.
At the last Mesa Public Schools meeting, actually, there was a woman from somewhere out of state who had a background in post-secondary education. And she said, in my state, when this was happening, what we did was when one person spoke about a certain issue, they asked everybody in the audience who agrees with that statement. And then that way they avoided repetition and the meetings would be shorter and more efficient. And I was like, this is brilliant. I love this. We should do this more often, because they do it already at the state capitol.
Yes, they do.
Mostly with people who agree with secular AZ's issues, but that's what happens down there. I think that's a good policy.
Right. So they can ban that. They don't have to sit there for 45 minutes and listen to that. But you have to have a school board president and members who will actually do it and are strong enough to stand up to these people and actually follow the law. And that's often the problem, is it not?
Yes, yeah. Some are great at gaveling, and some are not. Right now, I would say the example of gaveling is Ann Ordway in Deer Valley. She runs an efficient meeting. And that's the difference, because their meetings went from seriously 4 or 5 hours to an hour, hour and a half. It's glorious.
And that's the example of a good leader. What you can do, the difference between a good and a bad leader. All right, the board can prohibit disruptive behavior. And disruptive behavior is words likely to provoke immediate combat. That's the applies to the First Amendment as well. That's hardly relevant here. I mean, immediate combat, really. If I was toe to toe with somebody and, your mama, and they punch me in the face, their answer is going to be, well, she provoked me by using words that were intended to provoke immediate combat. Okay. That's not likely to apply at a school board meeting where the person is in front of the dais or in front of the podium and the people are up on the dais. So anyway, that's that. Going past the time limit, repetition, or, you'll like this, Jeannie, extends discussion by irrelevancies. A lot what they talk about is irrelevant. Am I right? Jeannie?
I would say 90% of what they talk about is irrelevant. Absolutely. Okay. So wait, you said immediate combat, repetition, and going off logic. Let's say the last part again.
Exceeding the time limits.
Oh, right.
Repetition or irrelevant.
Okay, there's so much irrelevance. Yes.
Yeah, exactly. Exactly. And the argument is it blocks a public body from accomplishing the public business.
Mm-hmm.
And there have been cases about this. So it could be litigated and it could be challenged if somebody chose to do that and had the wherewithal to do it.
Mm-hmm.
So the best court, but of course, these things are difficult to prove in court. And the best thing to do is don't have the comments, and then you don't have the problem. Mm-hmm. Another question that has come up is, can a school board ask the speakers for their name or whether they live in the district? And at 38-431.01, where it talks about meetings open to the public, and B4, it says, yes, they can ask for the names of the persons who are speaking. The minutes shall include the names of the people who spoke and a reference to the legal action that they were talking about. It doesn't say they ask for their addresses, but they can. I mean, how many meetings have you gone to where you fill out the little form with your name and address? That would then show them how many of these people were actually in the district and had a skin in the game, or were people that were coming in from elsewhere just to disrupt. Mm-hmm. So they could do that if they would.
Okay.
What happens if they disrupt the meeting? They can be arrested under a 1 or 2 class misdemeanor or a class 6 felony, depending upon what the action is. Now, we've probably all heard about that woman who was arrested in Surprise. Mm-hmm. I think it was city council, not school board. Is that right?
That's correct. Yeah.
Yeah. And they made a ruling that they couldn't speak bad about somebody, an employee, at the city council meeting. No, you can't do that. That is violation of the First Amendment. You cannot have content-based restrictions, and you cannot tell citizens they cannot complain about a public employee. That's the Soviet Union. You have to be able to complain about your public employees. Now, does that mean you can, spew out slander and defamation and all of those things? No, it doesn't. So they can be sued for slander and defamation. They could be if they are doing things like that. With a lot of the allegations that have been made about grooming kids and, sexual contact and this and that and the other, they can sue about that and have in Arizona and have. But if you're going to say this city council member or this agency head or this agency employee is stealing money, is corrupt, is not doing their job, is giving their friends priority or whatever, you can do that. So I know this woman has sued against her arrest, and our friend and Jeannie's best friend, Kavanaugh, has asked for an investigation about it. I don't think Surprise is going to get away with that particular one. Now, if she was in fact causing a disruption, then they could have done it. But the little bit part of the thing that I watched, the tape, the video that I watched, she wasn't causing a disruption. She wasn't swearing. She wasn't throwing anything. She wasn't, doing anything except making accusations. So I don't think they're getting away with it. It's a content violation so long as she was not disruptive. Mm-hmm. Okay. Other questions about open meeting law?
I have just a few questions, some about maybe open meeting law and some about just meetings in general and speech. Because, okay, So some policies will say there should be no politicking at the lectern, right? You cannot promote your candidacy. I don't know if that's a statewide policy or if it's an individual district's policy, but I've seen policies like that. And some districts also will even have it at the very beginning: no political speech, no promoting of candidates. What if you've got folks in the audience who are holding signs for candidates or wearing shirts for candidates? Is that considered politicking?
There is a state statute prohibiting politicking on school grounds. So it's not just a policy, it is a state statute. They can't politic on school grounds. So you can't get up and talk about your candidacy. If you're the candidate, you cannot get up and give a speech. Your surrogate cannot get up and give a speech. That would be politicking. So that can be prohibited. Now, signs can be prohibited. All signs would have to be prohibited. So you couldn't have a sign for one side of the ballot and not for the other. So they just should prohibit all signs. Then they don't have that problem. Wearing a t-shirt, they can do. Because that's a First Amendment thing. That is not a candidate pushing his own candidacy. It is a person speaking their First Amendment thought. So the t-shirt they can get away with, speeches from the podium, no. And the best way to get rid of the sign problem is to prohibit all signs.
Okay, that's sound advice. Okay, you said something about, okay, this may not be immediate combat, but what if somebody starts, like, using prayer, as we've seen, or scripture, I should say, scripture, to make very thinly veiled threats, like those whosoever stray a child, let them put a millstone. I mean, to me, that's, in my opinion, that is language that says, if you are not a Christian and follow what I believe, then I believe you should be dead in the ocean. Like, can you stop somebody from their fire and brimstone sermons that they keep giving at these damn meetings?
No, not unless that fire and brimstone sermon is going to lead to immediate combat, or it's irrelevant or not within this jurisdiction of the board. I mean, the board could argue that fire and brimstone and going to hell is not within their jurisdiction, right? It's not up to them whether any of this stuff happens. And that's not what we're here for. We're not here to determine anybody's religiosity or anybody's ultimate demise. We are here to focus on education policy. If you have something to say about that, say it. If not, shut up and sit down.
Mm-hmm.
You'd have to have a strong leader to do that.
Okay. All right. Yeah. And and I've seen a couple of people who start making threats, like, I mean, I'm sorry, but I feel like, calling a school board member evil or satanic or demonic, even though I don't believe in demons or Satan, it causes, other people in the audience to really believe that we're lizard people in, like, human skin.
Now, making threats is a criminal violation. There is a criminal statute about making threats. So it will depend upon the specificity of the threat and the possibility that the person really intends to carry it out. That comes the criminal prosecution, why they rarely happen, because how do you prove that they really intended to carry it out? I mean, the Supreme Court recently threw out a case, I think it was from Oregon, where the guy had sent all of these texts to his ex-wife, what he was going to do to her, and it wasn't nice. And she got an order of protection against him, and the Supreme Court threw it out, saying that his threats were not harassment and threats. Basically, number one, not understanding how domestic violence works, that it really is, he's going to do something because they do. And number two, not understanding the impact this has on the victim, is not that they care. So they threw that out because they said, well, okay, it's a threat, but, is he really going to carry it out? Is he really serious? Well, yes, he is. But anyway, they found no. So they just made it much more difficult to convict on a threat conviction. But there is such a thing. Now, as far as calling people evil and this and that, I would, if I were the board, I would say this is irrelevant. we're not talking about that. We're talking, give me the specifics about what your issue is.
Mhm. Yeah. Okay. So one other question, given the fact that it's really hard to prove, that there is an open meeting law violation, one of the violations, if I'm correct, is to share with the community before it's been publicly published, the agenda of the meeting. Is that correct? Because as a school board member, you might know or have ideas about what's going to be on the meeting, right? And but you're not supposed to necessarily, I mean, I guess perhaps I could say, we may be voting soon on a bond and override, and so pay attention to what's happening at your local meetings, to watch that discussion. But if somebody's going out and saying, this is going to be agendized and I need all of my sheep to follow me and complain to the board or whatever, if they publish that there's something that isn't publicly published, would they get in trouble for that?
I don't think so.
Okay. All right. I mean,
Because
yeah.
the board has to put out the agenda in a certain amount of time prior to the public meeting anyway,
Mhm.
right? So what the person is doing is simply with insider knowledge that this issue X is going to come up that week, and she knows people who are opposed or for issue X, and you're rounding up your troops. That's, I don't think that's a violation. I haven't looked it up, but it's just off the top of my head. I don't think so.
Okay. Let's see.
Now there was an issue, remember, about somebody publishing the results of an executive session, and that is absolutely prohibited.
Yeah. And I mean, we've gotten whisperings of that, right? Like in the instance of the school board member who's filming herself, right? She was filming herself in such a way that her camera was on her and you could very clearly hear what she was saying during the public meeting, but her mouth was away from the microphone. So she divulged what was being discussed in the executive session meeting through the microphone on her phone, but not on the recording, so nobody could hear it. So those are the kinds of like backdoor ways that these people will violate open meeting law. We can totally tell in some cases when, certain personnel decisions are going to be made at the school board level in an executive session, because there's suddenly a bunch of people talking about an executive session that you should know nothing about, that the public should know nothing about. So that's been a wild thing too. We do have one question in the chat. I want to get that. Yes, Rini, there will be a recording of this available. And yes, I think every school board member, regardless of what side they're on, although this should be it is an nonpartisan post, we should be focused on the kids. Forget it. But yeah, we'll have this posted. And I think that every single school board member, regardless of what side, should watch this, because I've already learned a whole bunch. There is a question here. Tonight at Horizon High School, people were asked to have a sign for school board candidates. Would that be a violation at a
Yes.
school event? Yeah, I would say so.
Yes. You cannot campaign on school grounds, period.
So okay, let's say then this is Friday night. I'm sure she's talking about Friday Night Lights. Football's super important, y'all. So they're probably going to be out there in the crowd. What recourse does that? So let's say you've got the banana whack jobs with all their signs out there. Who's going to handle that? And what if they don't?
Well, we've had these cases, this type of thing come up before. And as soon as I hear about it, I have made complaints to the school and pointed out to them the statute that says you can't do this. And in some cases, when it's been ahead of time, they have in fact stopped it. Other times they have not. When they have not stopped it, then you make a complaint with the Attorney General's office, and then you see what happens. In the prior Attorney General's office, absolutely nothing happened. In the current Attorney General's office, probably something would happen, but she's a bit busy with a lot of other things.
Yeah, that's a question that comes up quite a lot. Like, where's Chris Mays? Where's Chris Mays? And I say, first of all, the Office of Open Meeting Law was generally like a oopsie, you made a mistake office, right? Like, hey guys, you accidentally broke the rules here. You made a mistake. Just don't do it again. Maybe take a class. Here's an ASBA training.
Right.
Just don't do it again. But okay, losing my train of thought. Now now we have an attorney general who I believe really cares about this stuff, but she's so busy, first of all, undoing all of the mistakes of the last administration. And she's also focused on battling all of these court challenges to the abortion access law and everything else.
Her power.
So, yeah. So, I mean, I'm hopeful to see once these folks have maybe a couple years or even a 4-year term underneath their belts that they'll be able to more quickly address these things. But I feel like right now it's probably overwhelmed with complaints from both sides. Yeah.
But if anybody goes to this football game or anything in school and you see campaign signs for people, take a picture, send it to us. I can make a complaint to the school then, and hopefully that school won't do it again so that they don't have that problem. Because we have had success with that, with the schools themselves saying, whoops, I didn't even know I couldn't do that. So that has worked. So, but we need the proof. Your word is not enough. I need a picture. It's like those kids, if you don't have a picture, it didn't happen. So take that picture and send it to us.
Okay, so let's see. And then Sandra's asking, can I be across the street? The answer is yes, as long as it's off school property, correct?
Yes, that is correct.
So yes, put up all your signs. You missed a lot of the rage part, Ian. I'm sorry about that, but maybe we can catch you up with some added rage. I don't know. Let's see. I'm
Just
trying.
just to give you an example of one case that we did have a case where there was a sign, those huge big signs that candidates put out, attached to a fence at a school. In their fence around their, where people run in the football field and all that. And we got that taken down because they can't do that.
Mhm.
So if you see it, please do let us know. Take that picture, tell us where, when, etc., and we will file the complaint. And hopefully, we have to at least document it.
Yeah, yeah. So another thing that you brought up sign, or we're talking about signs. I know somebody in Scottsdale reached out to me to let me know that the Scottsdale Unified candidates, the pro public education candidates with like over 40 years of experience, so of course they're being demonized and misrepresented everywhere. But I heard that their campaign has now lost 66 signs that have either been destroyed, removed, or in some cases vandalized. Like, I mean, and the things that they're vandalizing on there, like, a friend of mine who's actually running, she's the former superintendent in the district where I ran. She's also a lifelong Republican, I might add, who's just sick and tired of Trump. Somebody wrote on where it said her name, pedophile. And then, for the other guy, it was, I don't know, groomer or CRT or like some of that stuff. But is there any recourse? That's a lot of money. It's a lot of money. It's against the law. And 66, like that is undemocratic. Is there any recourse for that?
Yes, there is recourse, but you got to catch who did it. That's
Yeah.
the tough part. What are you going to set up a camera across the street? I suppose you could, because it happens all the time. Signs are
Mhm.
destroyed, they're defaced, etc. But who do you arrest? You have to prove who did it. There's actually been video of people removing signs when it was happening frequently at a certain place. And this was the last election cycle. They actually did set up a video camera, hidden across the street or at a business or something or another that focused on where the signs were. And they did catch the people because they drove up in their truck. And so they got their license plate and all of that, who was taking and destroying the signs. So yes, you can do something about it, but you have to catch them. The police aren't going to be out there watching them. So either you set up your own surveillance or your own video camera, or how do you do it? There's no other way that I can think of anyway.
Mhm. Okay, I have one more question about school board members and free speech, because on this interview with Mike Broomhead on KTAR, board member Rooks from Peoria Unified School District, she went and also to this Arizona Women of Action training. In both cases, she was listed as board member, PUSD board member Heather Rooks. And again, Boardsmanship 101 says to board members, you are not an individual. Once a vote, you are a board member. You are not a representative of the district. So when she goes on these public forums and acts as if she is like she's speaking on behalf of the district when she says they're transing our kids, does the district then have recourse for her because she's misrepresenting the district she's supposed to be serving?
Here's the issue with that. There's, as you know, two different things. Can I go out and say, I'm speaking as Dianne Post, and that's my First Amendment right, and yes, I can do that. But I am now a commissioner on the Arizona Commission of African American Affairs. So can I go out and say, I am Dianne Post, commissioner on the Arizona Commission on African American Affairs, and saying XYZ? No, I cannot. That is not my First Amendment right, because I'm speaking for a governmental institution, which that is a governmental institution. So no, I cannot speak for them, nor can she. However, this is how people get around it. What is your memberships for attribution only, just to show that you are an involved community member or a renowned attorney or something like that? So I'm going to list you're a member of this, that, and that. You're not speaking for them, but you're a member of them, which boosts your credentials. So that's the slippery part where people try to get away and say, well, I wasn't speaking for the district. I was speaking for myself. They only attributed the fact that I am a board member, not speaking for the board. I am a board member, which is true, I am. So that's the argument.
Mm-hmm.
And again, from a legal point of view, with a strong First Amendment belief in this country, except for when you're reading books for children, that's difficult to overcome. Was it for attribution, or did she say the board of Peoria School District thinks this? Well, that's obvious. Then she's speaking for the board. Or Peoria School District does this, or thinks this, or wants that. Well, yes, then she's violating it, and that's easy enough. Most people are not dumb enough to do that.
Yeah, yeah. I shared with the district just in case they weren't aware, because I certainly would want to be aware, at any time, when I was on the board, if I got contacted by the media, I would, just because we weren't about like trying to attack each other, we were actually about trying to work with each other. So if I got a request from the media, I would just, as a courtesy, say, hey, just so you know, Channel 15 called. They want to talk about this vote on the SROs, and I'm going to be speaking with them. And I'd like to give out your contact information if they'd like it as well. That way, there's no surprises. There's no gotcha. You don't wake up and find out somebody in your district is misrepresenting the district. It's just common courtesy. And really, I mean, there's nothing wrong with being a stay-at-home mom. Nothing at all. Absolutely nothing. But I think for a lot of these women who are on the board, they've clearly never worked in a professional setting ever, and it reeks like it's so obvious, because there's no professionality, there's no professionalism, there's no collaboration. It's just some of the most immature, unprofessional behavior I've ever seen. And even though there's all these wonderful trainings offered by these, professional organizations, they don't take any of them. They only go to their right-wing ones and don't listen to anything. Yeah.
You know that there was a lawsuit by Heather Brooks about her alleged free speech abilities on the board. And this is where she cannot differentiate between herself as a person with the right to have a certain opinion and spout all the Bible verses she wants. She can do that. She can't separate that from her position as an elected public person on a body, and understand that in that position, she cannot spout all the Bible verses that she wants. She cannot seem to separate those two. And that's a problem of many of these cases where these people are violating that. So she's just doing what they do, and we'll see what happens with that lawsuit.
Yeah. Yep. We're all eagerly awaiting.
And as we're almost at the end of time and we're not going to get to any of the endorsements or anything, I would just say to check out the things that have been put in the chat. The now state endorsements, we've endorsed over 100 people, and we endorsed a lot of people down ballot. So the justices of the peace, the corporation commission, that sort of thing. So there are endorsements that you can look at for that. There are also for the judges, there's VIX Picks, which is now up online, and there's CEBV, which has their gavel watch. VIX Picks tends to be more
Harsh?
critical,
Yeah, critical.
more critical than CEBV. So you can look at both of them and then make your own decision about that. And then on the propositions, there is CEBV has their list of propositions, League of Women Voters has theirs, Now PAC has theirs, and we disagree, we being Now PAC, I'm on the PAC, on 140. We agree on everything else, no on everything but 139, that's the access, abortion access, and yes on that. They say, they being CBV and League of Women Voters say no on 140, I say yes on 140, and we do not have time to go into it.
Yeah, I think a lot of us, well, thankfully we've had this discussion. I think a lot of us are still on the fence about that one too. I'm leaning yes for right now, and hoping that we flip the legislature, but I can see why the others have have gone against it. All right, Diane, I'm going to end just like I do with everybody else. What gives you hope?
All the people working gives me hope. As I was telling Lindsay before this thing started today, I'm doing 4 things today for the election. 4 things, a meeting this morning with a phone bank, this thing, a phone bank this afternoon, and then a political meeting, fundraiser, drink a glass of wine tonight. I mean, it's every day. Tomorrow I'm canvassing. So every day, and the numbers of people who are turning out to work are fantastic. That gives me hope that we're going to go in. I'm going to keep going until November 5th.
We'll sleep when we're dead, right, Diane?
Right.
All right, everybody. I hope that you all have a wonderful weekend, and we will see you here next week. On Monday, we have a candidate forum for Catalina Foothills. On Friday, we have a candidate forum for Maricopa County School Superintendent. If you like this kind of programming, show us some love with a donation of your time, talent, and treasure. And thanks so much, Diane Post. You really are an Arizona treasure, and we appreciate
especially
you
for
so
the
much.
legal committee. We need to hire a lawyer.
Oh, yes. We need to hire lawyers. So all you out there, if you have any legal expertise, you don't have to be a lawyer. You can be what do you call them again? Paralegal, right?
Paralegal,
Like we'll take
investigator.
yes, we'll take any help that you've
I'll
got.
teach
So
you.
oh, there you go. You could learn from the very best, everybody. I'll take that class, Diane. Maybe I need to be your first student. All right, everybody. Thanks again. I hope you have a wonderful weekend, and I hope you're doing all that you can do to save our democracy. Take care, everybody.